Your Honor, Judge Allen, Judge Roberts, Judge Webster. My name is John Durr, and I am representing the Department of Children and Families and the Florida Statewide Advocacy Council. I would like to reserve 3 minutes, if I might.
All right, sir.
Let me address a couple of the questions that I heard on the earlier argument, because my case as appellant here is concerned strictly with the caps or the limitations on damages in 768-28, 5, and 8. First of all, I would suggest to the court that all retaliatory discharge torts in Florida have not been accepted by the courts. Traditionally, retaliatory discharge was a tort, and it was not recognized in Florida. However, the legislature, in adopting the retaliatory discharge provisions under the Workers' Compensation Act and subsequently adopting the whistleblower statute, recognized at least 2 types of retaliatory discharge. So the question is, does the motivation for the retaliatory discharge take the retaliatory discharge out of a common law tort and make it a statutory tort? And I would suggest not. That certain types of retaliatory discharge, a common law tort, have been recognized in Florida. Certain types have not. And we're concerned here with one of those types of retaliatory discharge, specifically retaliatory discharge for whistleblowing or for revealing some misfeasance or malfeasance in an agency.
Mr. Durr, the cases in Florida that have addressed this specific question are all against you, aren't they? There aren't many, but they're all against you, aren't they?
Your Honor, I'm only aware of one case that says that the whistleblower statute is not a common law tort, and that would be the Dahl case.
What about Branch versus Airtran Airways, decided by the Middle District of Florida?
I'm not sure about that, Your Honor. I don't know. I would suggest to the court that the legislature intended, by the legislative intent language of the whistleblower statute, the legislature intended the Public Whistleblower Act to apply not only to state agencies, but to independent contractors and to other public entities. These entities have different, and some have no, protection under the sovereign immunity statute. Certainly public contractors or contractors with a public agency, independent contractors with a public agency, might very well not be subject to the sovereign immunity statute. The Middle District of Florida recently considered a case involving the Lee County Mosquito Control District. It's an unpublished opinion. Kelly versus Lee County Mosquito Control District can be found in Westlaw at 2006-370-8100. That case, the court considered a motion to dismiss based on a failure to timely file in that case. And it held that it didn't really matter whether the agency in question was a state agency or a local agency, because the time was not met for filing in either event. But the issue of whether the agency is a state agency or a local agency might very well matter for purposes of sovereign immunity, for purposes of damages calculations. Similarly, recently in 2003 in Caldwell versus Board of Trustees of Broward Community College, the 4th District Court held that a Board of Trustees for Broward Community College was not a state agency for purposes of investigation by the Florida Commission on Human Relations. So the Public Whistleblower Act is not intended only to apply to state agencies, but to other agencies and other entities as well. And for that reason, it makes sense for the legislature not to specifically refer to 768-28 sub 5 and sub 8 limitations on damages within the body of the statute, but rather that those limitations come up when the court considers an action under the statute against an agency which is protected by those caps. I would suggest also that the issue in Maggio, that is whether the notice provisions of 768-28 apply to Section 760 claims, is not dispositive here for at least three reasons. And that is that the notice provisions of 768-28 and the notice provisions of Chapter 760 do not have any impact on any of the three reasons that the Supreme Court of Florida has identified as the bases for sovereign immunity law in Florida. That is, when there is a notice provision in 760 and a notice provision in 768-28, there is no impediment to requiring a claimant to comply with only one of those notice provisions, because it doesn't impact the orderly administration of government, it doesn't impact the state treasury, and it doesn't implicate the separation of powers. In the case of the whistleblower statute, if the sovereign immunity limitations on damages are not accepted by the courts, then the damages available under the whistleblower statute become unlimited, contrary to the damages available under 760.
What's wrong with that, Mr. Drew?
Well, I would submit, Your Honor, Judge Webster, that it is not likely that the legislature intended to limit damages on violations of civil rights, but not in cases where someone reveals a misfeasance in an agency. So I would submit that the legislature probably did not intend that result.
Wouldn't it create a disincentive for employees to expose wrongdoing in this situation if they couldn't get all their damages back?
That's a good question, Your Honor. The limitations on damages in 768-28-5 and 768-28-8 relating to attorney's fees do not prevent an employee from getting their damages back. They simply require that the legislature approve of whatever payments are made in excess of the cap. So the employee is not prevented from getting the damages. The legislature is simply giving control over the payout.
Until very recently, what's been the general history with regard to claims bills in the legislature?
I'm not familiar, Judge Webster, with that history, other than that I know from personal experience that claims bills do go through. I've had cases involving claims bills. We've all certainly seen claims bills that were very high profile that were handled by the legislature. And I think Governor Christ has recently proposed a settlement that would probably require a claims bill in a very newsworthy event. The issue of whether the legislature is to retain control of damages or payouts in excess of $100,000 is, of course, one of the principal reasons or principles supporting ideas behind sovereign immunity as identified by the Supreme Court. I also would like to point out that the Scott cases, both of them decided by the Supreme Court of Florida, came to the conclusion that retaliatory discharge, at least as it is identified under the Workers' Compensation Act, is a tort, and recognized that there was a long line of case law in Florida that retaliatory discharge is a common law tort. It said the Scott decisions, however, reported accurately that the state of Florida had never adopted that tort, but did recognize it as a tort. And the Supreme Court in Scott 2, Justice McDonald's dissent specifically points out that the issue of whether workers' compensation retaliatory discharge claims should be handled as contract claims was considered by the court and rejected. So we're rather left at the conclusion of the two Scott's decisions with the notion that retaliatory discharge is in fact a tort and is not a contract action, even if it does involve the issue of wages and benefits and back pay and reinstatement. I do want to point out in that regard that the Public Whistleblower Act, in terms of the damages section, does seem specifically directed toward reinstatement and back pay compensation for temporary loss of job. There's a provision for temporary reinstatement as well, pending a resolution of the whistleblower claim. Because, Your Honors, the statute is directed to a number of different kinds of entities, and because those entities each have differing interests or differing protections under sovereign immunity law, or perhaps no protection under sovereign immunity law at all, we would suggest that it makes sense for the statute not to address sovereign immunity, unlike Chapter 760, where the statute, the $100,000 cap at least, is specifically addressed. And if there are no further questions, I'll reserve the remainder of my time for rebuttal.
Okay. Thank you, Mr. Durham.
Thank you, Your Honor.
May it please the Court, I'm still Maureen Maddox, and I represent the appellee Margaret Rosa. I need to correct a couple of things. First, the damages under 112.3187 are not unlimited. There is no provision, and there are no appellate decisions on this issue yet, but there are a host of trial court decisions holding that emotional pain and suffering damages are not, in fact, available under 112.3187. So that actually goes to two issues. The first issue is that the damages are not unlimited. You've got a finite, calculable amount of money.
Economic damages only.
Only. And it says remuneration, other remuneration, that's been interpreted to be only economic losses. So in the Garrison case that I just argued, as a matter of fact, the jury came back and asked, can we give her more than just the economic losses? And the answer was no, you cannot. So she got $35,000. Margaret Rosa, in this case, got $143,000 or so on dollars, which were all her economic losses. So the damages are not unlimited. And second, in terms of a limit on damages, that the legislature intended for there to be a limit on damages, if the legislature had intended for there to be a limit on damages, the legislature would have said so. And there is no limitation on the damages under 112.3187. As a matter of fact, under the remedies section, under subsections 8 and 9, under the relief, it says that in any action brought under this section, the relief must include the following: reinstatement of the employee, reinstatement of the employee's full fringe benefits, seniority rights, compensation, if appropriate, for lost wages, benefits, or other lost remuneration, payment of reasonable costs, including attorney's fees, issuance of an injunction, temporary reinstatement. There is nothing in this statute that talks about emotional pain and suffering damages, which also, and I mentioned that it goes to the second issue, that it's it is a statutory cause of action that is in the nature of a tort claim, a statutory tort. But without having the compensatory damages, it is different than the damages that would be allowed under 768.28, under the traditional torts. So by having no compensatory damages available under 112.3187, it is different than 440.205. And I failed to make that argument earlier. It's not a traditional tort because we don't get emotional pain and suffering damages. They're not available to us at this point until the legislature takes action to provide for those damages under 112. We aren't allowed to claim those damages. Also, I believe that the issue still goes back to, and I listened to the appellant's argument about whether this is a tort or not a tort. The issue goes back to whether there's a separate waiver. and whether there's a separate waiver of sovereign immunity. And if there's a separate waiver of sovereign immunity under 112.3187, that is the issue, because you don't rely upon anything dealing with 768.28 to provide for the notice, caps, etc. But I did want to mention one case, the Gallagher, that is not cited in my brief, and I know Mr. Durr has also mentioned a couple cases that are not cited in his brief, but the Gallagher versus Manatee County case decided by the 2nd DCA last year. In the Manatee County case, the court considered the issue of caps on damages under 760.11. I am not arguing that that case is correctly decided. I have a feeling that I will be back before this court soon on that same issue before the 1st DCA. But the 2nd DCA has decided, and they have, the court relied, Judge Cannaday relied solely upon the incorporation of the cap under 768.285 and imposing the cap on damages under 760.11. So the sole reliance was incorporation of the cap under 768.28 on Gallagher. That language, and the reason that they can't argue Gallagher here, is because that same language the court relied on in Gallagher is not present under 112.3187. So the only issue, the only case that has been decided in Florida on the issue of the cap on damages under a similar statute has relied upon a statutory section 768.285, the cap on damages, that does not exist under the statute.
Ms. Maddox, Mr. Durr made reference to the fact that the common law tort of retaliatory discharge was recognized in other jurisdictions, although it wasn't in Florida. In those jurisdictions, does that common law theory of recovery authorize damages for emotional pain and suffering, or do you not?
Your Honor, I don't know. I don't know. All I can do is compare what we have under 112.3187 to what is available under 442.05. 442.05 is the only other statute, and I think there may be one other one, but that's the one that's most frequently used, the 442.05, which is just simply 2 sentences or a sentence. And it doesn't have anything like what we've got, the whole statutory scheme, the separate waiver of sovereign immunity, anything. It doesn't have that separate waiver. And at the risk of being redundant, I still go back to whether it's a statutory, what it's called is not that important. But is there a separate waiver, a separate independent waiver, and under this Court's decision in Clonas and under the Florida Supreme Court decision in Maggio, there is a separate independent waiver, and the cap would not apply if there's a separate independent waiver. And looking at the legislature's intention, and Mr. Durr has argued that, you can go in for a claims bill, and addressing Judge Webster, your question about what the legislature has done recently with claims bills, they have been disastrous for claimants. And claimants have not been entitled to any recovery. But the legislature said here that the relief must include the following. And to follow the legislative intent in this case, it would be wrong to impose a cap on the damages. The legislature would have said it. If they intended for there to be a cap, they would have said it. Thank you.
Thank you. May it please the Court. The idea that the legislature would have said that there's a cap, if it intended there to be a cap, is simply another way to argue that sovereign immunity has been waived by implication. And one of the basic tenets of Florida law is sovereign immunity is not ever waived by implication, at least as it applies to the state. Sovereign immunity might be waived by implication as it applies to the municipality or some other agency to which the state has extended sovereign protection. But it is not implicitly waived by any act of the legislature as to the state itself, because the basic default position, to use computer language, in the state of Florida is that the sovereign is immune. And unless the sovereign specifically waives sovereign immunity, it's not waived.
Mr. Durr, I'd like to ask you the same question that I asked Ms. Maddox. You indicated that in some jurisdictions this common law theory of retaliatory discharge is recognized as a cause of action. In those jurisdictions, did that common law theory of recovery authorize recovery for emotional pain and suffering?
Judge Allen, thank you for that question. I must tell you that I wish you hadn't asked it, because I do not know the answer to that
It's
question.
kind of important, if we're going to follow your argument, though, to see really how much this statutory action really looks like this common law theory from other jurisdictions, and because that's a pretty important consideration, seems to me.
I think that the answer may be found in part, at least in Scott, and that is the discussion by the court of retaliatory discharge under the Workers' Compensation Act as a common law tort, and the fact that I think the court in that case said that there were no emotional damages available for retaliatory discharge under the Workers' Compensation Act, implying at least that those damages would be available under the common law tort. I would also suggest, Your Honor, that even if, whether those damages are available or not under common law acts in other states, because the nature of the wrong is the discharge from a position from the job. But whether emotional damages are available or not in other states, the legislature could very well write a statute that says we are accepting a retaliatory discharge tort, but only under these circumstances, were the court to adopt it as a common law matter and say we are adopting wholesale the common law tort. You may not fire anybody for a bad motivation under any circumstances, and anybody who thinks they've been fired for the wrong reason has a cause of action. Then the court might very well allow emotional damages in that situation. But where the legislature says that we're only going to allow retaliatory discharge as a tort under certain motivations, under certain circumstances, not one of the elements of the cause of action generally, but under certain circumstances, that is, where you blow the whistle, or where you complain about discharge for bringing a workers' compensation action, only under those limited circumstances. And I think the legislature is also entitled to limit the damages that are available. And it may do that either by specifically stating the damages that it wants the court to consider, and then, where an agency is involved, sovereign immunity takes over. See, my time is up.
Your time is up, but if I may, if the panel will indulge me, I have one question I'd like to ask you. A cause of action for damages under Florida's Antitrust Act, would you say that's a tort action or a statutory cause of action?
Your Honor, I don't know anything about Florida's Antitrust Act, the blue sky laws. I couldn't answer that for you.
Okay.
Sorry, sir.
All right, we're going to take our mid-morning break. We're going to take about a 15-minute break, and again,